Division 1 is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in IDA Moorhead Corporation, Snaps Holding Company versus James Leach, our cause number 1CA CV15 0166. Let's begin with introductions of counsel. Sir. Thank you very much.
Good morning, Your Honor. Shelton Freeman on behalf of Mr. Lee.
Welcome and thank you very much. Let me go through a few preliminaries. Each side has 20 minutes, and if the appellant would like to reserve time for rebuttal, so you'll have some time for closing remarks, when you go to the lectern, if you'll let us know how much time you'd like to reserve, we'll try and make sure that we don't poach in that time and that you actually end up with it. Let me advise counsel and the parties that we have carefully reviewed the briefs. We have reviewed pertinent portions of the record, and we're familiar with the issues and the arguments you've raised. We are recording the proceedings today, both audio and video, and thus when you go to the lectern, if you would please restate your name so if a person is listening, they'll be able to identify the speaker. And I think with those preliminaries out of the way, we'll go ahead and begin.
Thank you, Your Honor. May it please the Court, Richard Crenshaw for the firm of Brown & Associates for IDA of Moorhead and Snaps, the appellants. I would like to reserve 4 minutes for rebuttal, please. Good morning, Your Honors. I appreciate the fact that you have reviewed the record and are familiar with the corporate history, and we don't need to belabor that because it's quite intricate. And I think it's one of the problems with the trial court's decision is the intricacy of the matter before it and probably the lack of time to do justice to that record. The trial court's judgment in this matter rests on several very shaky pillars, and if you eliminate any of them, the judgment must be reversed. In the first instance, it is important to keep in mind that the judgment that we are asserting below and here was acquired from a plaintiff in a wrongful termination action in North Dakota, where the corporations lie, North Dakota and Minnesota technically. This is not a case where we acquired a judgment as a co-defendant against another co-defendant. The intellectual model here has to be very simple. If you acquire something from somebody by assignment, you take it, except any reservations which were expressed, just as it comes. The basket goes with everything in it.
But Mr. Crenshaw, that wasn't the argument presented in the Superior Court. IDA took the position that UCATA applied and argued several UCATA principles, never arguing the law of simple assignment that you're asserting on appeal.
Well, Your Honor, Mr. Leach was successful in persuading Judge Barth that that was the issue. It was not. And we raised that issue from time to time. As pointed out in the
record, I can find that
in the reply brief, there's a citation to it. It is a...
Okay, maybe before your rebuttal you could find that, because I couldn't find anywhere in the Superior Court where you argued the law of simple assignment. I saw repeatedly that IDA urged the law of UCATA, which is what Judge Barth resolved the case on.
Yes, and he was determined that that was going to be the basis that we went forward on, and so we did. If you will look at, and I apologize, but this is because of the filing with the electronic filing system, our supplemental response to defendant's motion for summary judgment is between Exhibits 63 and 77 in the electronic index of record. At page 3 and lines 17 to 20, it is in fact covered that we urge...
What's the record site for that document?
It is, I apologize, it's between 63 and 77 because each exhibit had to be filed separately because of the electronic filing.
Maybe you can let us know on rebuttal what the exact number is, because we're not going to be able to locate it right now. But the point is, even on appeal, you're still arguing UCATA. You're arguing the single recovery rule, which is a UCATA principle. And the entire case was litigated in the Superior Court based on UCATA arguments. So it seems to me, as you know, we don't consider arguments raised for the first time on appeal, so I do want this specific citation that I can look at to what you're telling me you said you raised. I didn't see it in my review.
I will be happy to provide that for you, Judge
You
Downing.
were reading from, what was the title of the document you were reading from?
The one I was reading from was a supplemental response to defendant's motion for summary judgment.
And what page?
It is at page 3 of that. There's a citation to the record for that. There was also a
Okay,
piece
I
in
see
the reply
page 3.
brief.
Where on page 3 are you making the argument you're making now about a simple assignment, stepping into the shoes, et cetera? I see page 3.
Lines 16 to 20. Talking about our standing to raise the Newser's judgment, to assert it at all. And again, there's a citation in the reply brief that I can provide for you.
Okay, that would be helpful. Okay.
Thank you. All right. If contribution applies, and we assert that it does not, but if it does, then ARS 122506D and E allow contribution where vicarious liability is, in fact, still in effect. As a ruling from the North Dakota court, which unfortunately we did not have at the time of the trial, indicated.
Well, your clients had it. You're saying the lawyers didn't have it. Your clients clearly had it, we can tell from the record, because their own lawyer in that litigation sent it to them.
It was not available to us, however.
Well, here's my concern about that.
And we raised it by motion for reconsideration.
Well,
I apologize, Judge.
Here's the problem that I'm having with that. And I understand you personally or counsel may not have had it. The judgment that Mr. Leach attempted to domesticate from North Dakota, both the original judgment and the amended judgment, say right at the beginning, basically words to the effect, pursuant to the court's memo, opinion, etc., issued on such and such a date. So they're right in the judgment. There's a reference to another document or another court decision or another decision, a decision of the North Dakota court. Thus, it's not newly discovered, maybe new to you all, but it was available, it was out there, it was easily discoverable, and I don't see how we can say that would justify a new trial based, for example, on newly discovered evidence, because it was not new, and it was, in fact, discoverable.
If I may, Judge Norris, we're not urging a new trial. We are urging, in part of our brief, one of the issues raised was the failure of the trial court to grant a motion for reconsideration.
That's the point. Yeah, but what is the basis for reconsideration? Your clients conceded this was an intentional tort. The only way to get around that concession would be to say, oops, we made a mistake based on evidence we did not know about. So you really do fall within the newly discovered evidence rubric, and it just wasn't.
That was why we filed the motion for reconsideration, because the judgment had not become final. We thought it incumbent upon the trial court to realize what the North Dakota basis was for Mr. Leach's liability. We provided the decision. So it was not a motion for new trial.
Well,
it was
okay,
not properly a motion for new trial
Let's
law.
put that aside. It wasn't a motion for new trial, but nevertheless, this matter was briefed by both sides extensively. A lot of time and energy was spent in this. Your clients took a position, and only after the court issued a ruling and went into some length and detail, then all of a sudden it's, well, this position didn't work, now let's try something different. And that's normally parties are not allowed to take a position and then once they get a ruling change their minds and go off on another position. It's just not normally done.
All right. And I appreciate your comment, Judge Norris. It is what it is.
Okay.
And again,
Gotcha.
Counsel, let me ask, though, you say it's not a motion for a new trial. It's not classically a motion for reconsideration either, because you're asking the court to consider something that was not previously provided, correct?
correct. To that point.
Does that properly fall within the rubric of a Rule 7 motion as opposed to a Rule 59 or a 60?
It's not a Rule 59 motion because there had been no final judgment, so a Rule 59 motion was procedurally improper.
59 doesn't require a final judgment.
Well, it requires something in the nature of a final judgment.
It requires an order.
It's an order. Orders, judgments, and decrees are all the same under the rules.
Well,
But
but
just-
you had, I'm sorry.
Go ahead.
You had Commissioner Barth's determination on this matter 5 months previously, and so a motion for new trial under 59 would clearly be directed towards that. I mean, I'm repeating what Judge Thomas said, but a motion for reconsideration isn't the vehicle for raising totally new arguments in an attempt to get a 5-month-old order reversed.
Your Honor, I believe it is far less an argument than new facts, or at least new to us, if honoring Judge Norris's comment. We did not have access to that. Had we had access to it earlier, it would have been brought in earlier. Doesn't change the fact that we asserted that Denuser's judgment was what we were after, not a co-defendant's judgment. Okay. And again, if you even assume that, there's still other pillars. We are told consistently that the universal rule is that the acquisition or assignment of a judgment to a judgment debtor extinguishes the liability of the assignee, or the ability of the assignee to collect that judgment. And the assertion for that is based on AmJur 46, AmJur Section 441 judgments.
You know, let me just interrupt you, because I know that's an argument Mr. Freeman presses, but Judge Barth didn't rely on the extinguishment rule, and so would you rather spend your time on other issues?
I would cite, Your Honor, if it becomes a question, that the court should refer to Restatement of Judgments, 2nd, Section 50, which says that the rule cited in AmJur is no longer the rule. The majority says that unless there are reservations in an assignment of a judgment, the judgment goes forward and it's no longer a bar to collection. Very simple. Now, a great deal of Judge Barth's decision was findings of fact and conclusions of law. Both sides requested such according to Rule 51. If you look carefully at his final order, it adopts Mr. Freeman's findings of fact and conclusions of law wholesale. Not a single reference to any of the counter facts raised in our proposed findings and conclusions. Not one. Not a bit was devoted to saying, yes, I realize that that was a fact, but I find it improper, or I don't believe it because, or I choose not to honor it in any way. It goes back to my remark to begin with. I think the complexity of this was unfortunately beyond a commissioner's province. Commissioners do the scut work, and all of you know this from time being trial court judges. They move all the papers. And commissioners, correct.
And I would take exception to them doing scut work.
Counsel, let me encourage
Moving the paper.
Let me encourage you to address the merits of the argument as opposed to who made the decision.
Okay, that's fine, but again, I don't think enough time was devoted to actually looking at our submission, the findings of fact and conclusions of law, and saying, well, okay, if that's correct, what about that? There is absolutely no evidence that any attention was paid to what we submitted. None.
Well,
I mean, Judge Barth specifically made a finding that Leach's evidence was, quote, more credible and persuasive than the evidence presented by Snaps. So he clearly did consider the evidence, but didn't find it credible.
Your Honor, I read that as something that was included in the appellate brief, not in Judge Barth's order.
Well, no, it's directly in his order.
Okay.
On page 3 of Record 96.
Okay.
The evidence presented by Leach that Snaps was exercising substantial control over IDA and doing so in part in an attempt to thwart the end user's effort to garnish IDA's assets is more credible and persuasive than any of the evidence presented by Snaps, including, and then it goes on as to why Snaps' evidence wasn't credible.
Very well, but where did all that come from? The proposed findings of fact and conclusions of law, written by another lawyer, without comment, and again, without any attention
I
paid
don't
to
know
the
of any
contrary evidence.
authority in this state, and if you have one, please give it to me, because I promise you I'll go read it carefully. But I don't know of any authority in this state that requires a trial judge who has requested proposed findings of fact from both sides, to then explain why he or she decided to adopt this side's findings of fact versus this side. I mean, I don't know of any authority that says that level of detail, that level of explanation is required. And if you've got something, if you would, cite it and I'll go look it up.
I don't know that the rules require that. I think good practice does. If you have a record that reflects contrary interpretations of facts or plainly contrary facts, is it not incumbent upon the trial court to sift that out, or if they are having trouble with it, order additional briefing?
But doesn't the fact that the court rejected your proposed findings speak for itself, that the court did not adopt any of them, thus, and also based on what Judge Downey read from the judge's minute entry, the court then accepted that the evidence supported the findings raised or proposed by the other side?
So it says, my point still remains, there is no evidence that anything contrary was even considered. None. Nothing in a record.
And you come to that by the fact that the court entered the findings of fact that it did. That's the basis for that argument.
Without even consideration of anything contrary. Correct.
How do you know that that was not considered?
Because there should
That's
have
my
been
question.
at least 1, 2, maybe 5 instances in the record where the judge said the evidence is in conflict here.
But there's a difference between that and saying, as you have here this morning, that the trial court did not consider anything to the contrary. Those are different things.
I have no evidence in the record that there was consideration of anything contrary.
And
if
that's,
had it been.
If that's your argument, I understand that. If I heard you arguing something broader than that.
No. There's no evidence in the record that suggests that there wasn't any consideration of anything contrary. And had there been, there should have been comments about, well, the evidence is in conflict here. I choose to believe the other evidence, or I find the other evidence more persuasive instead of a blanket at the end.
And your point is we can't intuit that from the findings of fact that the court issued.
Correct.
Please continue.
I have another minute left before it is Mr. Freeman's turn. At the very end of everything, if you assume that Mr. Freeman is absolutely correct, there should be no contribution, that there was a unity of identities between IDA and SNAPS, which we reject for reasons that we've cited, there still remains one point. That is, Arizona law requires, in order to disregard the corporate entity, that there be all of those unities, but that it also work an injustice. That has never been shown. What the record shows, and it's in Mr. Freeman's brief, is that he can come up with a cogent explanation, or at least a plausible or stated explanation, that allowing the judgment to be enforced somehow works an injustice to Mr. Denuser. I don't see that. How does enforcing a judgment obtained by Mr. Denuser infringe on his rights or create an injustice in any way? And more particularly, how does enforcing a judgment entered against Mr. Leach by a trial court of competent jurisdiction in the state of North Dakota in any way work an injustice to Mr. Leach? There's no demonstration of such. None. At the very end, if all of Mr. Freeman's arguments succeed, but that one requires reversal, because there has been no demonstration of anything remotely resembling an injustice. I see my time is up. I'd like to reserve the rest. Thank you.
Good morning, members of the panel. My name is Shelton Freeman. I'm here on behalf of Mr. Leach, the appellee. Before I begin, I guess I would ask the panel members if there are any areas that you'd like me to focus on, so I can address those preliminarily before I provide comment.
I have one, and it's actually the one that Mr. Crenshaw ended with. Talk to me about the second prong of the alter ego analysis. We give great deference to the trial court's findings of fact, so let's say that unity of control passes muster under our standard of review. But what in the record supports Judge Barth's conclusion as to the second prong, that observing the corporate form would sanction fraud or promote an injustice?
Certainly, Judge Downey. If you actually go to EIR 96, which Your Honor referenced earlier, the judge indicated pretty clearly that the injustice that would occur would be as a result of IDA being precluded under rules of contribution from enforcing this judgment. And by having SNAPS pay for it and acquire it, it could then come to Arizona and enforce that same judgment.
Right. So his concept was that it would circumvent this very express statutory prohibition in both North Dakota and Arizona and do an end run around that. Is there anything, and that is what he said.
Mm-hmm.
And the injustice would have to be as to Mr. Leach, because Mr. Danuser's not really a player in this particular setting, correct?
That's absolutely right, and I think that's part of the confusion. Many of the cases that are cited really don't deal with the situation we're facing. They deal with a claimant versus co-joint tortfeasors. Here we're dealing with the assignment by the claimant to one party who was a co-joint tortfeasor and its alter ego. They're attempting to exercise their rights under that judgment now. And so, as the cases discuss, yes, there are great efforts to protect a claimant, but once that judgment's assigned to a co-joint tortfeasor, different rules apply. And so here, those rules are you don't get contribution for an intentional tort, and essentially buying the judgment yourself or through a third party, you can't get around those prohibitions on contribution, because that would unfairly just expose Mr. Leach to liability on a judgment that effectively has been satisfied by IDA and SNAPS.
I recall there was an Iowa case that Mr. Crenshaw cited for a different proposition, and as I recall, it also holds that you can't use an assignment basically to get around a statutory prohibition against contribution. Is that?
Yes, that's, I believe, the right.
Does that have any application to this second prong of the injustice to observe the corporate form?
I believe it does, Your Honor. I think those theories meld essentially that the concepts of the extinguishment rule that we argued really have their basis in exactly this result, in that you can't use an assignment of a judgment to get around the prohibitions that are built in against contribution among joint tortfeasors.
More public policy type.
Agreed. And so, in particularly here where you have express statutory prohibitions, essentially to take those steps in the face of those statutes, I think is even stronger. We raised the extinguishment rule issues because we felt it gave the backdrop to kind of where those came from.
I got too messy.
I completely understand, Your Honor. It is a very messy area, and I think that's, again, if for example, if you looked at the Bishop case that they cited, the court. At the trial court was confused, and I think the parties were confused about offset rights for contribution versus, between the claimants. And that's why I thought it was really important to say, claimant's gone. They got what they wanted out of this deal, and they assigned the judgment. So we're not in that environment. We're looking purely at a contribution right.
May I follow up on Judge Downey's question, please?
Certainly, Your Honor.
A lot of the cases on the second prong of the alter ego test deal with a situation that, from a factual standpoint, if the corporate formalities are honored, then the I'm going to call it the other side, the claimant. The claimant will not be able to recover relief, such as Mr. Danuser. If he still had been the judgment holder, he would not have been able to arguably collect his judgment because of the transfer of all the assets. So that would make sense. So piercing the corporate veil protects the claimant from being deprived of relief. So it's more factual. Here, the second prong was really satisfied by saying, well, if we don't pierce the corporate veil, there would be an end run around a legal principle. And I see a bit of a distinction between end running around a legal principle versus depriving a plaintiff or a claimant of their right to recover because of a switch of basically changing the corporate form.
Completely agree, Judge Norris.
Yeah. Do you have did you cite a case or find any authority that talks about the second prong, that it can be sufficiently broad enough to encompass basically an end run around a legal principle?
In terms of the injustice aspect,
Right.
One moment. I think the Haskins, Wright v. Haskins case did deal with that issue, whether they put it in that terms or not. But in terms of, if I may, we discussed specifically
Well, I can read it. I don't want to delay
Okay.
your time, but I'll take
yeah, I
another
believe
look.
Wright v. Haskins talked specifically of saying you can't allow through an assignment someone to do, that would be an injustice to allow them to accomplish that result.
Okay.
And I do think, again, it is important to say, if Dan User were still the holder of this judgment, I think he could pursue Mr. Leach for any shortfall had he not assigned the judgment. I don't think we have any argument with that. But once he said, I'm paid in full, I'll assign my judgment to IDA and SNAPS, he's out of the picture now, and all the rules change because we don't have that protection of a claimant. And the case law that we've cited talk about that change from a claimant debtor obligation to a co-debtor obligation. And that change is important, and I think it supports this notion that once you get to that level, you can't play games. You can't subvert the rules about that through an assignment to a third party or to yourself. And I think that's been our position, Your Honor.
That issue, what's our standard of review for the second issue of the second prong of the alter ego?
I believe whether there's an injustice is a fact-finding because the trial court had to find that Mr. Leach would be subjected to injustice as a result of this alter ego. I do believe that there is a legal component to that as well, so it probably would be both standards would apply to that, I believe, Your Honor.
Since you asked if we had questions, I know Mr. Crenshaw is going to tell me where in the record I might find IDA's argument in the Superior Court that this is a simple assignment to which assignment law, not UCATA, applies.
I can point you to the sentence if it would be helpful, Your Honor. I
The
found
sentence? Okay.
It's actually on page 3, line
We're talking about record item what?
EIR 63, Your Honor.
63.
And it's on page 3, line 21. Or excuse me, I apologize. It's between 19 and 20. It says, Leach is not a creditor, and in fact, SNAPS now stands in the shoes of Dan User pursuant to assignment of the judgment. That's the whole stand in the shoes argument that they presented. No
That's
case
under
law.
the fraudulent transfer.
Correct.
It's item 63 of the record.
Yes, Your
Yeah,
Honor.
I've got it right here.
Yeah.
Okay, yeah.
Okay, thank you.
Yeah.
Is it your position that argument was waived in the Superior Court? It seems to me as if the issue proceeded by both sides under a UCATA track.
Absolutely, Your
The
Honor.
single recovery rule is a UCATA principle, and I didn't see this litigated in that context in the Superior Court.
And if Your Honor will look at this record, and I know you have, I mean, we had, I think, 5 hearings, a number of briefings. There were plenty of opportunities to bring these issues up. Our Commissioner Barth was incredibly open to allowing parties to raise the issues along through the process, and it wasn't brought up. And when we had our trial, there still could have been the opportunity to raise that, and they didn't. And as Your Honor's pointed out, that issue never arose until, now in an opening brief. So we don't believe we had an opportunity to address that below. And again, I don't think that analysis would even change the outcome for the very reason we're discussing. Stepping into the shoes of Dan User, you can't ignore the fact that IDA is a co-obligor on the judgment. I mean, this notion that they keep saying, well, we're really not enforcing the judgment, against IDA. Well, that's the only judgment is against IDA and Leach. You can't separate those two. So when IDA acquired the judgment against itself, I mean, to me, there's a merger argument there. I mean, that's when a joint tortfeasor acquires the judgment against yourself, it's done.
Or you adopt the Wright versus Haskins.
Exactly, that it's satisfied. And I think that's from my perspective, that's really what happens if one intentional tortfeasor settles with the claimant and it gets an assignment of that judgment, it's extinguished because there's no right of contribution. So there is no right left to go collect it against anybody. And it's ironic. I mean, 2501D says exactly that in our statute. If you look at that, I mean, I in preparing it says a tortfeasor who enters into a settlement with a claimant is not entitled to recover contribution from another tortfeasor whose liability for the injury or wrongful death is not extinguished by the settlement. So right there in the statute, they embrace that notion. I mean, it doesn't come out and say, yes, the judgment's extinguished, but those concepts are clearly anticipated in there. So, from our position, that's exactly what happened here. And I guess as to the injustice argument as well, Commissioner Barth didn't feel like I'll take this on. Like, I couldn't persuade him of the impact of what really happened here, because recall that Mr. Leach sold the company to Snaps. Snaps still owed Mr. Leach a lot of money for that purchase. They've not paid him that money as a result of this. They've asserted indemnity rights under that contract. So not only were they asserting those indemnity rights, they were trying to acquire this judgment against him to collect twice. Not only assert indemnity rights, but also try and seek affirmative recovery. That was the injustice we argued. Commissioner Barth wasn't able to, like I said, I wasn't persuasive enough, but those facts are in the record, and we put on testimony to that effect. I think in terms of injustice, there were several layers of it, and I think the conduct that was demonstrated by Snaps in its treatment of IDA and how it handled it was amply provided in the record, and I think the court had ample support for entering the findings that he did. I am aware of no rule or provision or case that suggests that a judge is obligated to note each proposed finding or conclusion and describe why they're not adopting it. But I do think Commissioner Barth made it clear that he didn't buy the evidence that was presented by Snaps and IDA here, and that he did believe the evidence presented by Leach was convincing. I will point out, at the trial, we didn't call a witness. We didn't call Mr. Leach to the stand. My witness, Mr. Patel. That was our case, Mr. Patel's testimony, and Mr. Patel had testified in a deposition in the fraudulent conveyance case. So between those two items, that was a big part of our case. So this notion that, those were their own client's words, Mr. Patel, that the judge heard and determined their credibility on and entered his findings. So we believe there's ample support in the record for the findings made. We believe he correctly applied the law, and unless your honors have any other questions, we would ask you to affirm the decision.
Thank you very much.
Thank you.
Thank you, Your Honors, and thank you, Mr. Freeman, for providing the citation, which I would have been glad to give Judge Downey. However, there are other evidences of raising that issue in the record. If you'll look in a minute entry of October 17, 2014, which is ER 89, and the following minute entry, ER 90, you can see that the issue of IDA's standing to enforce the judgment was raised by Mr. Freeman during an argument. Court-ordered briefing, there was later a stipulation that we did have such, and we prepared a brief which was never filed because of that stipulation. It became unnecessary.
Tell me again, because Record 90 is simply a minute entry setting a hearing.
Mm-hmm. Same thing.
It says it's ordered setting a telephonic hearing to put their settlement on the record. That is,
Yeah, and the settlement on the record was that we had standing to do this, so it was no longer an issue. There's been a great deal of attention
Well,
paid.
forgive me, and I don't mean to beat a dead horse, and the bailiff will have the bailiff grant you another minute while I ask my question. I don't see a debate over standing being the same as raising the assignment arguments that were raised in the briefing on appeal.
Part and parcel of the same thing. If you don't have standing, then you cannot say that it
Well,
is.
but clearly your clients was an assignee. There's no question about it. They were an assignee of IDA. I mean, the agreement says that, basically. The issue then is what can they do with, in light of that transfer, that assignment, what are their legal rights under the law with respect to being a joint tortfeasor with Mr. Leach. That is the next step from the assignment, and I don't see that issue.
Your Honor, it was raised in the very first proceeding where we were in. You need to realize that we didn't domesticate the judgment. It was done prior to our appearance in the case. It became apparent that, to use your phrase, and I was going to use it myself, that raising the issue of whose judgment it was beating a very dead horse. I've never felt comfortable in telling a judge, you're wrong, you're wrong, you're wrong, you're wrong.
That's why people tell me that all the time. It's okay.
Yes, and probably every judge in the trial court thinks that at least once a day about the Court of Appeals.
I'm sure. I'm positive.
But making the record is making the record. You then go with the flow. You argue what the trial court is interested in. The trial court was interested in Ucata, and the case did go off on the Ucata issues. We simply didn't want the other to be forgotten, and it wasn't. The issue of standing is part and parcel. Whose judgment is it? So, there. Again, strangely enough, the issue of merger was raised for the first time just a moment ago. It's not briefed anywhere. It was not briefed below. It was not asserted. And I think it's specious. There's no such merger here. What we had was simply a judgment that we took, again, as a full basket from Mr. Denuser, trying to enforce it against the judgment debtor. What is unjust about that? If there is an injustice in that, then every time there is a loser in the superior court of a money judgment, enforcing it is per se unjust. It can't happen that way. You spoke of an end run, or an end run was spoken of during the appellee's argument. No such thing as an end run. We were enforcing something that we acquired for value.
Well, that's their argument. I didn't mean to suggest that I had prejudged this, but that's essentially what Judge Barnes said.
And understand that that was the argument. It's just wrong. If we buy something from Denuser and pay value for it, we get it just as Denuser had it, and it comes with all of his rights, including the right to enforce it. Again, how in the world does that raise an injustice? It can't.
You know, that case that you do cite from Iowa Wright versus Haskins says you can't take an assignment as a method of getting around the prohibition against contribution from a joint tortfeasor.
And again, I refer you to Section 50 of the Restatement of Judgments. There was no reservation in the assignment of judgment.
Did you cite Wright versus Haskins?
I did, yes.
Yeah.
And, the case stands for what it stands for, but the principles that led to the extinguishment rule, and again, something you mentioned earlier, I'm out of time, I'm sorry.
Go ahead and finish off your answer.
You mentioned earlier that the single satisfaction rule was a Ucata issue only because it's codified there. That rule is as old as the common law, has its roots as far back, I believe, as Blackstone. And it simply reflects that a party cannot be satisfied more than one time. All IDA and SNAPs were attempting to do was be satisfied one time. Would Mr. Leach get credit for anything else received or paid for the judgment? Absolutely. But Denuser, and therefore IDA and SNAPs, should be entitled to enforce a judgment acquired, again for value, to settle a very messy lawsuit in the state of North Dakota and allow business to go forward. Thank you.
Well, I would like to thank counsel for both sides, their argument and briefing today. We'll take this matter under advisement and issue a decision in due course. Thank you all.
Thank you.